particularly robust research operation, licensing revenues if they license their patents to companies, and spin-offs because universities will oftentimes take financial interests in those companies. So it is in everyone's economic interest to make sure that these universities have a viable economic return on their research dollars, and that they get those research dollars in the first place. And I'm going to talk to you about three parts of the bill, and you've heard about at least two of them so far, that are of particular concern to universities. The first is the first to invent system, the second is the grace period, and the third is something called post-grant review. I'll deal with each one of these. Now, I take it at face value that there will be a constitutional debate over first to file, and especially after the arguments I heard today, there should be. My comments today, however, put that aside. In other words, even if there is no constitutional problem with the first to invent system, it will be a detriment to universities. Now, you heard the comment that the first to file system is basically a one-size-fits-all. Everybody has to do business now the way IBM does it. In the case of universities, it's not a question of changing the paradigm. They don't have that option. We're talking primarily about institutions that have finite resources for filing whatever inventions, applications on whatever inventions come in the door. And ordinarily, these resources, for the vast, vast majority of institutions in this country, require a very detailed review process that makes it imperative that the tech transfer operations in these universities have a sufficient amount of time to look over the inventions and find out of the dozens of invention disclosures they get, which one should actually be the subject of a patent application. The first to file system essentially says you can't do it that way anymore. Basically, when an invention disclosure comes in the door, to make sure that you are entitled to a patent on that invention, the first thing you need to do is put together some sort of an application, whether it's a provisional or not, and get it on file right away. For most universities, that is just not a realistic possibility to do that for every single invention disclosure they get. So essentially, you're putting the universities in the position of either filing indiscriminately on the first however many it is until their budget is used up, or not filing at all. Neither one of those is a particularly good option, but those are the options that universities have under a first to file system. There was talk about this reason being, the reason for first to file being a harmonization provision, basically harmonizing US patent law with that of the rest of the world. Now, I worked on the Romanian patent law in 1991 after the revolution, and that was, in fact, a first to file system, as are systems around the world. In countries where they don't have the same culture regarding litigation of patents and companies setting up what I will call a picket fence of defensive patents, first to file may make sense. Here, however, where we have a particularly litigious culture regarding patents, and companies in fact do go out and file patents or patent applications on things solely for defensive purposes, not because they intend to use the inventions ever, a first to file system probably doesn't make as much sense. And as I said, will be very detrimental, at least for a significant portion of the people out there who are beneficiaries of the patent system. The second thing I wanted to talk about, which is related to first to file, is the grace period. The grace period, as you heard, basically says, now, under the current system, you have a certain period of time without losing your patent rights to figure out if there's something really worth filing on, taking your time, looking at it, and even if it's publicly disclosed, you have 12 months to get something on file. If you do away with that grace period, effectively you're saying to the universities, you no longer have that option either. This can't be vetted in public anymore, and under what's called the 102A grace period, it can't be vetted really in private either. So the universities lose that, what I will call essential capability to look at these inventions to really prioritize what they want to file applications on. There's another aspect as well, especially in academia. Oftentimes, inventions arise out of the collaboration of researchers from multiple institutions. Obviously, these are different legal entities. It is possible that in such a circumstance, if collaborators begin talking about what I will call inventive material amongst themselves, that could be considered some sort of a public disclosure that may, in fact, destroy whatever patent rights there might otherwise be. And I can assure you, given my review of dozens of university patent portfolios, the value of this interinstitutional collaboration in coming up with inventions shouldn't be underestimated. Some of our best inventions come from colleagues in a particular technical art talking to each other and figuring out in a synergistic fashion, basically, how inventions can be made better and how inventions can be made at all. That is at risk if, in fact, the grace period is done away with. The final thing I wanted to talk about is post-grant review. So basically, this provision says that within a year after the issuance of a patent, anybody who isn't the patent owner can go ahead and challenge the validity of that issued patent. Under the current statutory framework, there are seven separate mechanisms by which an infringer can challenge the validity of a patent. I won't name them all for you, just trust me, it's true. This adds an eighth. And the problem is that even under the existing statutory framework, an accused infringer can combine these different mechanisms to delay effective patent enforcement for years. I am personally involved in one case that was filed in 1996. It's been up on appeal to the Federal Circuit 3 times. It's been in re-examination now for the last 7 years, and that was after 8 years of district court litigation. And the problem with the post-grant review process is on the face of the bill, the provisions say that that particular mechanism can be used in combination with other mechanisms to challenge the validity of a patent. So here is yet another weapon in the arsenal of an accused infringer to challenge the validity of a patent and at the very least delay any effective enforcement. So those are the 3 provisions that I wanted to bring to your attention from the university standpoint. And if you don't mind, I'd like to follow up on the one issue you mentioned, the canard about we don't give inventions to the first to invent. When a patent's been publicly disclosed, in that circumstance, no one gets the patent. So it's not like in that circumstance, whoever is second gets one. No one gets one. So it's not really even an exception to the first to invent rule. In that circumstance, there is no patent awarded to anybody. There is a very, very limited circumstance under the first to invent system whereby if someone has invented something a long time ago and then abandoned, suppressed, or concealed it, that person won't be awarded a patent if someone comes in after that. But that exception is so rare, I can tell you that in my 25 years of patent litigation, I've never seen it happen. So not only is it an exception, but it is the rarest of exceptions that one can probably find under the law. Thank you.
Would you just mention, George, the economic impact on the states that these universities have?
Well, as I mentioned, I mean, effectively, you're talking about institutions that, if they are not self-sustaining, it's obvious that that money has to come from somewhere. So on the one hand, you're talking about an economic burden on the taxpayer when the potentially millions of dollars of licensing and spin-off revenue come in. Secondarily, in the states that have done this very well, and for example, the Research Triangle in North Carolina, Silicon Valley in California, a variety of other states, Wisconsin, for example, with the University of Wisconsin, these states, the universities in these states have had an enormous economic impact on the local economy by creating jobs, by creating the technologies that are basically exported around the world. So you have basically 2 parts of the equation. Number one, the decreased tax burden on the taxpayers locally in the event universities are able to derive revenue. And on the other side of it, actually a positive economic impact by virtue of the jobs that are created and the economic boosts that the resulting technologies can create in the form of businesses and jobs.